Everyone may be seated. Wait till the door closes, and it is closed. All right, Mr. Summers. I suspect that you're the only potential witness at this time. Is that correct?
That's correct.
Okay. I want you to think about it, sleep on it, and let us know in the morning. Now, when I ask you, that's the first thing that I'll do in the morning is address you, and they call it a colloquy, where I ask you questions about whether you've had sufficient time, and that's one of the reasons I'm giving you overnight to do that. And I'll ask you what your decision, if you've made a decision, what your decision is, if anyone's forced you or threatened you in any way to make that decision, just so you know what the questions that I'm going to be asking you tomorrow. And just to go over the procedure again that we discussed earlier, so you know all of the things and any other things that you should be aware of. You will testify in a narrative. I will swear you in front of the jury, just like I've done all other witnesses. You will come down to the witness stand, and then you may testify. As I said, the state may raise objections. I don't know what objections, but any objections that are raised, I'll rule on at the time. I do not know whether you have any prior criminal history, but one of the things that comes up when a defendant testifies is if they have certified copies of prior convictions, that opens the door to that. So I just want to let you know that. Let me actually ask, say you have any copies of certified convictions for Mr. Summers?
Yes, Judge.
What's the number?
We have 4 worthless checks, Judge. So crimes of dishonesty.
Okay, so misdemeanor crimes of dishonesty. All right, so they intend, if you take the stand, to introduce that. Not the nature of, state, you don't intend to say what they are, just...
He answered incorrectly.
Oh, well, yeah, I'm going to get to that. But they're going to ask you at some point whether you have ever been convicted of any felonies or crimes involving false statement or dishonesty. They're indicating they have what they believe are 4 that would be an affirmative to that. If you acknowledge that, then that's the end of it. The jury doesn't hear what the charges are. If you don't acknowledge that, and they are actually entitled to introduce the certified copies of conviction. That's why they have to have them, and then they will go back and the jury will see the certified copies of conviction. I just want you to have all that information and know all of that while you're considering your position whether to testify or not.
I understand that, Your Honor. And I didn't get a clear answer, but is also when those crimes occurred available to the jury, or just the fact that they were convictions?
Well, that would be up to you. And if they ask about it, you certainly can provide additional facts. Those are the only facts they can go into. But if you want to go into details of it, you're absolutely entitled to. All right. Anything else? Anything from the state?
No, Judge, are we going to do the charge conference now?
Well, not till I just am uncomfortable until he testifies, or makes a decision. Obviously, it would be perfect if we knew he wasn't testifying, but it'll be a good point for a break. We'll go through, but I appreciate that very much, Ms. Johnson. Mr. Summers, I want you to read, I think it was the proposed instructions are 60 pages long. Okay, now some of them we've already given, and it's actually going to be page 14 through 60, it looks like.
I have a copy on Monday, Judge.
Do you still have that copy?
I believe it is here, Your Honor.
Well, I want to make sure you have one. We'll print you another one.
I have them here.
Oh, you do have it. All right, so very important homework tonight. Read those instructions. After you rest, whether you testify and then rest, or whether you rest before you testify, we're going to have a charging conference. We're going to go through one by one each and every one of these 56 pages, and I'm going to ask whether you're in agreement to the instruction. I honestly haven't read them yet, but I suspect that they're standard instructions, and I will address any objections that you have to any of the instructions, and also at that time consider any instructions that they haven't proposed but that you wish to propose. You understand that?
Yes, sir.
All right, so read these instructions so that it'll go smoothly tomorrow.
Judge, I did notice for count 8, neglect of a child.
Tell me what page.
25.
Mr. Summers, if you'll turn to page 25, please.
The initials of the child in count 2 should be BS, B as in boy. I've updated that on the electronic copy. I just wanted to let you know and Mr. Summers know while he's going through them this
Okay,
evening.
and I appreciate, and if this is the stack we'll that we're going through, I'll scratch through it tomorrow, or we'll print out that. And you let us know any other changes that may be different in that stack. But I appreciate that, and Mr. Summers, if you can at page 25 just acknowledge that the actual proposed instruction changes the initials. All right. Anything else from the state?
Nothing from the state, Judge.
Anything from the defense, Mr. Summers?
No, Your Honor, I'm good.
All right, everyone have a good evening. I'll see you in the morning at 8:30.